the reports into the Ivory Coast dumping have not been correct. They and their lawyers have gone to great lengths to keep the full details of the story out of the public domain. But the international repercussions are making that impossible.
Well, with us now are Mark Stevens, media lawyer, and Matthew Nicklin, media barrister, who's represented, among others, Madonna. It's extraordinary that you can get to a point where an injunction could possibly prevent the reporting of something in Parliament, isn't it?
Oh, it's completely ridiculous and frankly unprecedented. I mean, we have a situation where the resolution or the question that Paul Farrelly MP put down in Parliament was on Parliament's website. The injunction couldn't reach Parliament's website. It only prevented publication in England and Wales, yet people in America, in Australia, throughout the Commonwealth, on Twitter and social networking sites were looking at this around the world, while we here in this country couldn't know what was going on in our own Parliament. How
have we created a climate where that sort of thing is possible?
Well, it's a recognition that there is a competing interest between freedom of expression and other people's interests. Now, there is always going to be that interplay between the rights of freedom of expression, very important, and the rights of people's reputation, privacy interests. Now, what this case exemplifies is that there is a hard edge coming up against parliamentary privilege, and it's a very important constitutional principle that what happens in Parliament should be reported.
Well, this is absolute arrant nonsense, because, you know, since the times of John Wilkes, we've always tried to have an open justice system. We've always tried to have everything open and above board, and we're not having it. And we don't know what our parliamentarians are up to, as long as judges are prepared to grant injunctions, which Matthew Nicklin is prepared to represent, to large and wealthy companies to prevent us knowing.
Yes, but Mark, you know very well that the courts aren't always open, and there are competing interests that apply there. Many family proceedings are held in private, particularly to protect the interests of children.
So there's not an absolute reason.
There's not an absolute rule. Now, the parliamentary rule that we currently have, that everything is fair go in Parliament, may need to be looked at. The question is, if somebody can suffer real harm...
So your position is really that the public shouldn't be able to know what's going on in Parliament?
No, not that at all. But Mark, you have to recognise that on occasions there will be things said in Parliament that can cause people real harm. And if they're wrong, that person has no redress.
But do you also defend the right of people to seek an injunction and then seek an injunction which says that we may not even know there is an injunction? I mean, how many things could be out there that we're not allowed to know?
In certain circumstances, it's obvious that that's going to have to be part of the relief that's claimed, because if you have a story which is partly out in the public domain, you need to be able to, if it's a privacy story that's designed to protect somebody's privacy interests, the fact of reporting, the fact they've applied for an injunction will put them under intense scrutiny and pressure, and essentially it will cause, because of the internet dimension, it will cause the fact eventually to come out and frustrate the purpose of the injunction in the first place.
But what you're actually doing by taking these proceedings, and Matthew Nicklin and his ilk have been in the vanguard of this over the last couple of years, of developing trials, secret trials in this country, where people go off and they get an injunction and the newspapers can't even report the names of the parties that there is an injunction in place. The newsrooms of this country absolutely rammed full of these secret injunctions, and finally it's out, and it should be a public disgrace, and Parliament should investigate it.
Is there some peculiar rot to the English system that this has been allowed to happen?
No, it's nothing new. I don't know why Mark says that this is a problem that's a new thing. The courts have always retained the right to restrain publication, which will frustrate the very purpose. If you are bringing privacy proceedings to vindicate a privacy right, the last thing you want to do is expose the very thing you're trying to protect in the proceedings themselves.
I understand why it's good for business for people like you that Australians, Russians, Israelis or whoever can come to this country and seek some sort of legal redress which actually has no real location in this country. It's good for you guys, of course.
Well, I'm not
sure
that's
good for us.
It's not sure the principle that applies. I mean, you can't just turn up at an English court and say, hello, I'm from some far-flung jurisdiction, I'd like some remedy, please. You've got to be able to prove that there's some reason why the English courts...
I'm sorry, that's absolute arrant nonsense. We're at the moment entertaining in our courts a Ukrainian oligarch who has come here to sue a Ukrainian language website based in Ukraine, which just happens to be accessible to the 1 or 2 people in this country who can read Ukrainian. And that is, you know, we're paying for that as English taxpayers. We're paying for judges and courts to service that case. As absolute nonsense.
Is that desirable?
Well, I don't know I don't know the case Mark is referring to, but the process is
perhaps.
Well, if it is simply a Ukrainian person suing over a Ukrainian newspaper and the defendant is Ukrainian, then on the basis of the law is at the moment, it would be very difficult to bring a claim here.
But isn't this turning us into a sort of joke country?
Well, we are a joke country. The Americans are having to enact legislation. We've already seen it in New York, New Hampshire, Illinois, Florida, Hawaii, and yesterday Governor Arnold Schwarzenegger passed it into Californian law to prevent, by statute, the enforcement of English judgments in America in relation to libel and privacy, because they do not conform to international standards.
Well, they don't
That's a really undesirable situation. You've got a jurisprudential diplomatic incident.
They don't conform to the American view of what freedom of expression means. America has the First Amendment. It doesn't have the sort of complicated balance of rights that we have in the European Convention.
So what you're advocating,
there are two clashes of cultures.
What we have, Mr. Nicklin, is a situation where you are advocating that the Americans last night were twittering, tweeting, SMSing all the information about Paul Farrelly's question, which is now to be published today in The Guardian, because the Americans published it yesterday. That makes us a laughingstock.
No, but that principle is well recognised. It was well recognised in the Spycatcher case. The English court doesn't grant injunctions in vain. If the reality of the situation is that everybody in the rest of the world can read it, the English court won't maintain an injunction.
Okay.
You know that. It's been the law for years.
OK, chaps, thank you both very much indeed.